All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same James Arlington Cole who was placed on deferred adjudication in 2000?
Boom. The judge comes in swinging with zero sugarcoating. Right away, she frames this as not just a legal issue, but a moral one. Question for you. Should judges confront defendants this bluntly, or does it risk biasing the case?
19 CR 9039 for the offense of aggravated assault with a deadly weapon on February 12th, 2024 for a period of 6 years. Is that you?
Yes, ma'am.
All right, state.
Violation condition number 4.
Oh, and I'm sorry, could you announce for the record?
Rick Payne for the state of Texas. My apologies.
All right, you may proceed.
Violation of condition number 14G on or about the 31st day of May 2025 in Bear and or Harris County, Texas. The defendant, James Arlington Cole, did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited Battering.
Quick legal note. 14G refers to mandatory counseling for domestic violence offenders. Missing classes can mean instant violation. In Texas, this isn't just skipping school. It's the difference between probation and up to 20 years in prison.
Intervention and prevention program in a violation of condition number 14G.
How do you plead to that? True or not true?
True. Your Honor, I had.
Just one moment.
Judge, we're
State.
gonna be doing true with an explanation.
All right. So with regards to the other violations,
State will waive the other 2 violations, Your Honor.
any objections?
No objection.
Did you understand by pleading true to violation of 14G, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 14G?
Yes, ma'am.
Court will find 14G true. Is there proposed agreement?
There is not, Your Honor. Both sides are going to go open to the court with our recommendations.
All right, state, what are you recommending?
To revoke the defendant's probation, adjudicated guilty, and sentence the defendant to 6 years TDC.
All right, and defense?
Judge,
We have witnesses or,
no witnesses, Your Honor, just argument.
all right, what are you requesting?
We're going to be requesting for Mr. Cole to be placed back on deferred adjudication, and we like to explain what was going on with the MTR.
All right. Let me hear
And,
explanations.
let me
Yes.
explain. First of all, on the BIP program, his deferred was transferred to Harris County. That's where he's from.
So here's the twist. The defendant actually did 11 out of 12 classes. He was kicked out over money, not misconduct. That raises a huge debate. Should financial struggles really undo months of progress in rehab programs?
He completed a lot of the BIP program over there. He was exited from the program because he didn't make his payment for the BIP program. Our best estimate is that he completed maybe almost 90%. He was talking about graduation.
So here's my question.
Mhm.
Do we have proof that he was exited from the program for non-payment? No, you can lower your hand. So here's the thing. Let me explain something to you. You're saying I was exited from the program because I was unable to pay. Okay. Your client, your attorney saying he was exited from the program because my client told me he was unable to pay. It's like, where's the proof?
Can I speak, Your Honor?
Well, let me just be clear. So is this for failure to pay? That's what
That
is
is, that is our understanding, Judge. I don't know if probation has any more information beyond that, given the fact that this case.
Well, let's call probation in Harris County.
Okay.
And let's see if they'll zoom in. And if this is about payment, then we'll see what's going on.
We can find out.
All right?
That'll be fine. Okay, Judge.
Yes.
Part report dated June of 4th of 2024, and when the month of May 2024, it indicates in the 11th of 12 sessions. And at the bottom of the report, it indicates that it is an outstanding balance. However,
Mr. Dill, can you, I can't see her.
However, I don't have any other updated progress after that. From the BIP program itself.
All right, State, have you reviewed that?
I have not reviewed that, but I'll take her
All right,
word
so
for
if
it.
y'all want to review that, what I can tell parties is this. If the only allegation the state is going on is 14G, and it appears from what Ms. Abrams has said, the progress report she received, there were 12 classes for BIP. He completed 11, and then they say that there's a balance that's due.
Yes.
And I'm assuming the balance that's due is not a balance of another class, but of funds. And what I can tell parties is, I don't see how it will be appropriate to revoke him if he's done 11 BIP classes. He only has one more to do,
Mhm.
and he owes a balance.
The court wants additional arguments, I'll go into it, but I'll wait for the court.
May you say so back to the motion?
Yes.
Thank you.
Sure. You want to confer with the state as well?
Yes.
Okay, thank you.
Okay. Have a seat for a little while. Okay.
So are you all ready?
For Judge.
All right, Mr. Cole?
Whoa! This isn't his first violent charge. Even though the new case got dropped, the judge knows his history. Do you think past allegations should weigh this heavily when the evidence didn't stick?
Is there anything else?
I have an argument if I could make before you make your ruling, if that's okay.
Yes.
Reason why state's recommendation is what it is because he is on probation for a 2018 offense of aggravated assault with a deadly weapon. 3 years later, he picks up a misdemeanor assault, bodily injury married co-head, which unfortunately we could not go forward because that victim was uncooperative, but it was a different victim.
All right, so I will listen to what you have to say, but let me explain something to everybody.
Yes.
You all are only going on 14G. And that's the only thing that I have before the court. Now, I see the motion to revoke, and I see there is a violation of number 1. There's a violation of 14U. But the only thing I've been presented with is a violation of 14G.
Yes, Your Honor.
And he's on deferred adjudication. And 14G, and if there's a disagreement on the facts that I've been given, let me know. The facts that have been given to me about 14G is he didn't complete his battering intervention and prevention program. There were 12 classes. He did 11. They kicked him out of the program because he didn't have money, and they're waiting for the balance. And then I guess he can take the final 12. That's what I'm dealing with. If people want to go on other violations, I'm willing to hear that. But you all have just gone on 14G. And what I have on 14G, I don't, it would not be appropriate to revoke someone who's done 11 of the classes. They only have one remaining. And the reason why they didn't do that one is because they didn't have money to pay for it. Now, if somebody wants to present some information to me that he could have paid for it, he just chose not to. He won the lottery. He chose not to use it for that. He chose to do something else. I'll hear that. But I'm just here for 14G.
And Judge, he did not win the lottery. In addition, Judge, he was doing really well the past year and a half. This is his first MTR. He's on deferred. He's employed. He has a CDL. He's a truck driver. He hasn't tested positive for any substances. He's tested all the time and come up negative. If you test him today, Judge, just in case there was any doubt, he would come out negative. He's been in jail in custody for about 30 days already. And we believe that if and he is motivated to get back on deferred. If you place him back on deferred, Judge, he's going to do anything the court wants him to do. If you want him to do the BIP course all over again, he's more than willing to do it.
Well, I don't think it would be appropriate to redo the entire course when he only has one class remaining. Is there something else, State?
I make one more additional argument, Your Honor,
Yes.
which I would assume pays well, and he's had a year in which to try and take care of that particular non-payment to the BIP issue and has failed to do so up to this point in time. Additionally, Your Honor, if Your Honor does not feel like revocation is appropriate, state would, and if Your Honor is considering continuing on probation, state would ask that Your Honor add a jail sanction to his probation that begins today.
All right. This is what I can tell everybody. There's one outstanding class. Am I correct in that?
Correct, Judge.
It appears so, yes, Your Honor.
And this motion to enter adjudication of guilt and revoke community supervision was filed on June 12th, 2025. And we'll have to look in to see when he was actually arrested on this, because sometimes motions to enter adjudication of guilt, they're signed, they're filed, and then if he was in Harris County, and if he were arrested in Harris County, he would have needed to be brought back to Bexar County. So these are your choices. You know yourself better than I do. You know yourself better than your counsel does or the state does. I do realize that the state is only proceeding on 14G. I don't understand about this thing from North Carolina on June 8th, 2025.
About high stakes, the judge narrows it down to probation with conditions or straight prison time. Imagine being in that hot seat. Would you gamble on probation, knowing one slip means 20 years?
But these are your choices. I can continue you, or I'll sentence you to 2 years in the prison. Those are your choices.
Which one do you want? You want to be continued? You want to?
Well, I can tell you right now, based upon what's in the motion to revoke, maybe truck driving is not for you, because the violation, and I'm not considering it, the state didn't present any information, but I see it where it's alleged to have been committed in North Carolina. And I think that's related to he's driving his truck in North Carolina. So maybe he should not be allowed to drive in other states.
Absolutely. Now, I've had a discussion with my client, Your Honor, and if placed back on deferred, he knows that, if he gets in trouble again, he's going to be back in front of the 187. So he understands there can be, bad consequences. So, but he has reiterated to me, he does want to be placed on deferred, back on deferred, and he'll do whatever the court asks him to do.
Well, if he wants to be continued and deferred and continue to drive a truck, I'm not going to allow him in the state of North Carolina.
I think he'll agree to that easily.
Is there anything else?
If Your Honor would, as you just mentioned, you can see it when you provide evidence of the number one, but just consider the fact that even after doing 11 of the 12 BIP courses, he picked up that number one. That's all I'm gonna say.
Well, I don't know if that rises to the level of preponderance of the evidence, which is the standard of proof in motions to revoke. I don't know if that's something that rises to the level of proof beyond a reasonable doubt. If it's for a jury trial, I just see that there's something in North Carolina.
I present this to Your Honor if Your Honor would be willing to look at it over Mr. De Leon's objection.
Judge, I'm going to object to that because they waived the number one allegation. So that's something for the court not to consider.
All right, that'll be sustained. So I'm to deny the motion, alternate amendment conditions. There's to be no contact with the state of North Carolina unless he's ordered to be there.
Okay,
legally ordered to be there, not by your employer says you need to drop off a load in North Carolina. You're not allowed in the state of North Carolina unless in the state of North Carolina,
Thank you.
they have a hearing for you in a court of law.
Yes, ma'am. Understood.
Is there any other conditions you request state?
For the defendant as well. Part of the terms of this probation to have no contact with Tamisha Singleton. And that's, if I can spell it for the record, Your Honor.
You said Tamisha?
Yes, Tamesha, and then Singleton, Singleton.
we have no objection to that, Judge.
All right. All right, so there's to be no contact with Tamisha Singleton, no.
And there's the hammer. The judge goes beyond sentencing into personal judgment, calling out deeper issues of violence and self-control. Do you agree with judges giving this kind of life advice? Or should they keep it strictly legal?
Residing with minors, no unsupervised contact with minors. And you're gonna restart the BIP course.
Yes, ma'am.
And Ms. Abrams, that needs to be restarted within 15 days. Is there anything else?
Nothing else, Your Honor.
Thank you, Your Honor.
All right, we can go off the record. Here's the thing. I didn't really consider that number one because the state didn't proceed on the number one. But I did allow you no contact with Carolina because, of course, you see things and it's alleged to have been committed in North Carolina. It appears that you are a person who should not be in a relationship because you don't know how to keep your hands to yourself. So you need to work on self and figure out why you may or may not, because I don't know anything about that case, are abusive towards people you claim to care about. Because at some point in time, you're going to run across somebody who's somebody's brother, mother, or sister who's going to be very upset with you that you're mistreating their relative, and they're not going to tolerate that. And if something were to happen, you know what people are going to say? Oh, well, you should have kept your hands to yourself. So I don't know why you can't do that. Do you know why you're unable to do that?
Your Honor.
Tell the judge what you can do in the future.
Well, no,
Yes, ma'am.
not what you're going to do. No, not what you're going to do in the future. Why can't you keep your hands to yourself? Why do you keep being abusive towards people you claim to care about or claim to love?
It wasn't my intention.
No, I don't want to talk about your intention because you're here. And the reason why you're here is because you cannot keep your hands off of people that you claim that you love. So I don't want this, it's not my intention, because it is your intention. You know, maybe after something happens, people have regrets. They want to cry, buy somebody flowers and say, I love you, it'll never happen again. And then the next thing you know, it happens again. And then people start gaslighting people, making them think it's their fault.